SJC-13660, Commonwealth versus Elena Gaston.
Okay, Attorney Rosev, whenever you're ready.
Good afternoon. May it please the court, my name is Anne Rusev and I represent Elena Gaston. This case presents an issue that this court has never confronted, and that is whether a potential future claim of ineffective assistance can create a manifest necessity for a mistrial. But I don't think this court actually needs to reach that broader question, because the question presented on these facts is actually much narrower. And that is whether there was a manifest necessity where, one, the judge erroneously inferred a complete lack of consultation based on counsel's statements about the opening. Two, where the judge appears to mistakenly believe that the defendant's explicit consent is required prior to a concession. And three, the defendant neither alleged a lack of consultation.
So if a defense attorney argues jury nullification and examines on jury nullification, what's the judge to do? Just let it go forward?
Well, in terms of the jury nullification issue, I believe the judge addressed that. That was sort of the first potential basis for the mistrial that he considered. He gave a forceful curative instruction, and he found repeatedly and explicitly that the jury could and would follow it. So there could be no prejudice to the Commonwealth.
Then the defense attorney just does it again, right?
Well, no, I think when you look closely at the record, you'll see that even prior to the evidentiary portion of the trial beginning, there's some motions in limine about what kind of questions can be asked. And he says, even though force and coercion are not elements, you are allowed to inquire about that. And the judge says, there wasn't anything surprising about the cross-examination. I expected there to be questions about lack of force, lack of coercion. So I think that where the judge has given that forceful instruction and where he has found repeatedly and explicitly the jury can and will abide by it, that sort of closes the book.
But it's sort of a combination, isn't it? Because it's not just that the opening argued jury nullification. It's that the opening foreclosed the only defense that had been articulated by defense counsel to the judge, which is lack of knowledge. So the opening did two things. It both removed, it basically undermined that defense, the only defense, and then also argued jury nullification. So don't we need to look at that, both of those together when we're reviewing the judge's decision to allow the mistrial or grant the mistrial?
I disagree, because you have the trial judge making that factual finding that the jury can and would follow the curative instruction. And under Arizona v. Washington, we defer to that trial judge's assessment because the trial judge observed the jurors during their voir dire. He observed the opening as it was given. He observed the tone. He observed the jurors during the curative instruction. And for those reasons, we have to defer to the judges.
Was there a finding that the judge believed that the instruction would be followed, or
Yes.
was it? Okay.
Yes, he does. And I can...
But I think the judge said that that was based on his assessment at the time he made that ruling. And then after that, there were 3 witnesses called.
Right.
And the subject matter of the cross-examination, the subject matter of the cross-examination continued down the same line, which was lack of compulsion, right? It didn't try to do anything with the maybe a legally relevant line of defense.
Well, again, I would say, well, just as an initial matter, so the judge adheres to his conclusion that the jury could and would follow it.
So you want us to defer to the judge's findings, the first finding, and then ignore the judge's finding later on, and say there's an abuse of discretion?
No, I'm not asking you to ignore the finding. I'm saying the finding about whether the efficacy of the curative instruction is a particular type of finding that we defer to. And the judge does say it's at page
Right.
185.
Then unrepentant, the lawyer just keeps doing the same thing, witness after witness, correct?
No, I disagree, and the judge disagreed as well, because when the Commonwealth makes that argument, the judge says, actually, I was not surprised by anything that happened during cross-examination. We had this discussion prior to trial that he would be allowed to inquire into that. It's not an element, but it's a proper basis for inquiry. So I think that the judge has addressed that situation, and you have to defer to his finding on that. And he does continue to adhere to it on Monday, the day of the mistrial. So if you look at the transcripts, page 12 and 14, he says, I continue to believe the jury would follow this instruction. And it's not until the Commonwealth raises this issue of lack of consultation that I am now reconsidering. I came into court today ready to reaffirm my denial of the mistrial. And then the Commonwealth raised this issue for the first time, and on the basis of that, I find there's manifest necessity. The problem with that finding is that it's predicated on this erroneous factual finding that there's a total lack of consultation, right? What trial counsel says is, I didn't talk to her about my opening specifically. There's no other information. The judge asks him once, he says, no, I didn't speak to her about my opening. The judge later says, well, didn't you just tell me you didn't talk to her about your opening? And he says, yes, that's correct. Those are the only two questions we
Isn't that a
have.
But isn't that enough? I mean, so I go back, and it's nice to see you again, Counsel, to Justice Wolahojan's point. If you're the defendant, and you know going into trial that the only lever you have, the only arrow in your quiver is lack of knowledge, and then you have, that's on one hand, and now you have a seasoned defense lawyer saying, I never discussed the opening, where I'm going to torpedo the only legal defense, because the other defense of jury nullification isn't a defense, right? The only legal defense that I have to this, I did not talk to her about. So why isn't that supporting the trial judge's finding on that? That's the only, she only had one legal defense going into trial, and now you've got Attorney Carney saying, I never discussed my decision to get up there and say, I'm going to argue for nullification, which necessarily is going to undermine the only legal defense that you had.
So just to be specific again, he says, I never discussed the content specifically of the opening. He doesn't say, I did not discuss strategy in general, I didn't discuss a concession in the closing, or anything like that. So we're tied to just, they didn't discuss the content of the opening.
The content of, I'm going to argue nullification.
Right. So in that sense, the test for ineffective assistance in a tactical decision is extremely high, right? Manifestly unnecessary, manifestly unreasonable, excuse me. That's essentially a search for rationality in counsel's decision.
Within the ethical bounds.
Sure. And you cannot do that type of search without more information here. So that type of claim, as this court has said in Evelyn, needs to be advanced in the context of a Rule 30 motion. If there is a claim that the opening was manifestly unreasonable, then we address it in a post-trial context where you can develop a collateral record. You can get an affidavit from the client, you can get an affidavit from counsel, and in that post-conviction context, you have a waiver of the privilege, right? If it's the defendant who's lodging the claim, the waiver of the privilege happens, and then you can fully explore what was the extent of these conversations, what was the content of these conversations, and most importantly, you can address prejudice. When you have a full trial record, we know all of the evidence that came in, we know all the arguments that were made, you can make a determination about prejudice. Here, 3 witnesses testified. There were some questions about knowledge. I believe one of the witnesses was asked, do you know for sure what Ms. Gaston knew? Would she have known what happens on the dates? And I think the witness says, well, she wasn't there, so I don't know for sure what she would have known. There's still many witnesses to cross-examine to come, right? The trial was expected to last about 5 days of evidence. So we're at the beginning of this trial. It's impossible to say at this early stage what the ultimate defense would have been, what the ultimate closing would have been. And it's not uncommon, it may not be best practice, but it's certainly not uncommon for strategy to shift between opening and closing. Sort of a classic example is where defense counsel makes a promise that some exculpatory witness is going to testify, often making a promise that the defendant is going to testify, and then for some reason that promise is not fulfilled. That type of shift is not necessarily ineffective assistance. We simply don't have enough information on this record to know what would have happened had this trial proceeded. Would Attorney Carney have been able to sow some reasonable doubt? Would he further explore, the lack of knowledge issue? Maybe there would have been an acquittal on some charges. Maybe not. And if there was a conviction, would a reviewing court look at the full trial record and say, there is no prejudice here because the evidence was simply overwhelming? Those are both possibilities, and we don't know what would have happened had this trial been allowed to go to verdict. But the test for the manifest necessity is extremely high, right? We don't know what was going to happen here. It was speculative to assume that, one, there would be a conviction and there would be a way to establish prejudice. And its speculation is not enough. Under cases like Elder, under cases like Illinois v. Somerville, there is an extremely demanding test for a manifest necessity. Reversal on appeal must be certain. It must be inevitable, and we don't have anything approaching that here. Is it possible? Yes, of course it's possible, but you cannot say it's certain or inevitable that after trial, after maybe a dozen more witnesses have testified, a very experienced trial counsel gives a closing argument, it is not inevitable that there would have been a conviction and that there would have been prejudice.
Okay, thank you.
Thank you so much.
Attorney Nixon.
Good morning. May it please the court. Assistant Attorney General Nicole Nixon, appearing on behalf of the Commonwealth. With me at counsel table, is Assistant Attorney General Jennifer Snook, who is the trial prosecutor in this case. The Commonwealth is asking this court to affirm the denial of the 211-3 petition by the single justice. After providing the parties with multiple opportunities to be heard and carefully considering possible alternatives, the trial judge determined that there was a manifest necessity for a mistrial. As the record makes clear, the trial judge came to his decision only after reasoned consideration and thought regarding whether a mistrial was appropriate and the unusual circumstances created, solely by trial defense counsel's improper conduct. Ultimately, after balancing the defendant's right to have her trial completed by a particular tribunal against the Commonwealth's and the public's interest in fair trials designed to end in just judgments, the trial judge justifiably determined that the Commonwealth's and the public's interests outweighed the defendant's here. Reiterating the findings he made on the record when he declared the mistrial, the trial judge in his decision denying the defendant's motion to dismiss stated, "It would have been fundamentally unfair to consign the Commonwealth to continue trying the case to verdict without any prospect of obtaining any verdict in its favor that could survive appellate review." Because that was the posture in which trial defense counsel's deliberate and strategically improper conduct placed the Commonwealth, the court was ultimately left without a doubt that there was manifest necessity for a mistrial. Now, as the record makes clear, the judge's thoughtful and reasoned decision was clearly not an abuse of discretion, nor did the single justice abuse his discretion in affirming the trial judge's reasoned findings. As this court and the Supreme Court has made clear, there's no prescribed formula for determining whether a manifest necessity exists to warrant declaring a mistrial. And
Can I just follow up with you on the issue that Attorney Rousseff? So if the single justice is looking at what the trial judge is doing, we hadn't heard all the evidence. I agree with you. I've never seen anything like this from somebody this experienced. But we both know that opening statements are not evidence and that the judge was going to specifically instruct the jury that it wasn't evidence. So considering that there were still witnesses to come and that there still might have been some ability to adduce evidence on the lack of knowledge to be able to effectively argue at closing for an acquittal, does this really reach the high bar, other than the fact that the opening is absolutely nothing like I'm sure any of us have ever seen before, that the trigger was pulled too quickly?
Your Honor, I don't think so, and I'll give you a few reasons for that. I acknowledge, obviously, we all know here, opening statements are not evidence. However, the opening statement explicitly conceded her guilt as to the two main charges. And again, the judge would instruct that opening statements aren't evidence, but it's hard, I think it would be hard for the jury to get that out of their minds and then believe a defense of lack of knowledge if the defense attorney was in fact going to go forward with that, which that's not even clear from the record. I think if you look at the cross-examination of the witnesses here, there was almost no questioning as to the defendant's lack of knowledge as to her employees engaging in commercial sexual activity. But even taking that as it may, I think that even assuming, and jurors follow instructions, obviously we take that assumption, the case law makes that clear, but the defense attorney's entire opening was geared towards jury nullification, and in that jury nullification strategy, he expressly conceded the defendant's guilt on many occasions.
Well, I think there might be a distinction between factual guilt and legal guilt. I agree that the defense counsel basically conceded factual guilt through the argument that he made. But did he concede legal guilt?
Your Honor, I think he did, because I think he explicitly made statements that conceded that the defendant committed each of the elements of deriving support from prostitution and sex trafficking. I'd point Your Honors to the Commonwealth's opposition to the motion to dismiss. That's specifically at Record Appendix 57 through 58. In that particular section of the opposition to the motion to dismiss, excuse me if I said motion to dismiss, the opposition, I mean, the prosecutor in that opposition goes through some of the statements the defense attorney made and how those statements were concessions of each of the elements of deriving support from prostitution and sex trafficking. I can also give you some examples here. One example is, this is a direct quote from the defense attorney's statement. It's at Trial Volume 3, page 52. The defendant came up with this idea for a way that she could help other prostitutes and at the same time make money doing so. I think that concedes elements of deriving support from prostitution. Another one, the defendant was providing a service for a man and a woman to meet and have sex. It was organized so that the woman and the defendant both benefited from this. Again, I think that concedes all of the elements of deriving support from prostitution. As to the sex trafficking charge, there was a quote, this is a direct quote, Trial Section 3, page 55. The defendant also had the woman also had women be driven to where the meet would be with the John. And when the woman got up to the hotel room or went into the John's home, the defendant said to the woman being provided, please call me when you get here. I think this concedes that the defendant provided and transported women to male clients to engage in commercial sexual activity, meeting the elements of sex trafficking.
So if you have all of that, and say we agree with you on that, I'm still intrigued by this last part. All of that happens, and there's still not the declaration of the mistrial, but then we get to the issue of whether or not the defendant was aware that this was going to be the defense counsel's strategy, and that was the sine qua non to the declaration of the mistrial. Is there enough here? And I don't know if we need all of the things that we heard before, because I do think you have defense counsel essentially waiving the privilege by saying, I didn't discuss, he's talking about confidential communications. It would seem to me that he's saying that in open court. Do we need more here to really have an evidentiary record to support this, that it was unknown?
Your Honor, I don't believe so. I think the trial judge's findings on this point are sufficient to make his reason finding that there was lack of consultation before these concessions of guilt and before this abandonment of the only factual defense that was available to the defendant. I'd point Your Honors again to the record. Trial transcript 4, pages 18 through 19 and 23 through 24. That's where the judge explicitly asked the defense attorney on the record, did you consult with your client before making this opening? And I think it's important to look at the substance of the judge's questions because that informs the defense attorney's answers. The substance of the judge's questions were really geared towards, did you discuss the substance of the opening with your client before doing so? Meaning, did you discuss that you were planning to concede her guilt before doing so? And I think the judge's questions really make that clear. I also would point the court as support for the judge's findings as to lack of consultation, as to the breakdown of the plea colloquy. That happened a day, I believe it was a day prior to the trial starting. If you look at trial transcript 1, pages 27 through 37, that's where the judge engages in the colloquy with the defendant. And
That's where she won't concede
Exactly.
that she knew.
Exactly. And it's clear from the record that she's at the very least uncomfortable conceding that she knew. And then she ultimately says there has to be a trial. So I think if you look at that in conjunction with the defense attorney's explicit admissions and also with the judge's observation that he made on the record of the defendant being visibly upset after the openings and the curative instruction being given, all of those things, when taken together, clearly supports the judge's finding here.